I'm Anna Bradley and I'm the chair of the SRA, and I'm delighted to welcome you to the 2024 Compliance Officers Conference from Birmingham. We've got at least 1,100 people here today, which is fantastic to see. And we've had some fascinating conversations already about the risks that we're seeing in the sector, whether that's about big firms failing or about bulk litigation, and the way that we need to address those as a sector. We started with a conversation between myself and Paul Phillip, our Chief Executive, talking about some of those emerging risks and the big issues that we have been dealing with this year and will be dealing with during the course of the next year. There's also a really important session on the first outcomes from our consumer protection review. I hope that you will remember that from the beginning of this year, when we started to look at what we might need to do in order to reduce the risks in relation to client account holding and ensure that the compensation fund is sustainable for the future. We've done that first round of consultation and are today beginning to talk about some of the proposals that we will bring forward and which we very much hope you will continue to engage with us on, because your contributions to shaping the changes that we make will be very important indeed. Of course, this is a compliance conference, so an awful lot of what you will be able to see as you watch these virtual sessions is about key areas where we think it's important that you look at your compliance risk and make sure that your firms are fit for purpose. And chief amongst those is always the very popular and much attended session on anti-money laundering. I know that lots of you really value being able to join this conference virtually. It was, if you like, a positive bonus that emerged from the COVID period where we couldn't gather people together, but we're delighted to continue to do that. And in particular, we will continue to do this year what we've done in the past, which is not just to give you the opportunity to hear the sessions from today's conference in recorded form, but also to have hands-on Q&A sessions with our expert panels. So you can still ask your questions, and I hope you'll do that as you listen to the sessions that you choose to attend. So it really just leaves me to say thank you very much for joining us. I hope you find it valuable. We really want to know whether it is and whether it's hit the right spot and raised the right issues. We're always keen to have your feedback, so please do make sure that you give us that feedback when the opportunity arises. And let me leave you with the first of those sessions on anti-money laundering.
All right, well, welcome to day one of the virtual conference. And a big thank you to Anna Bradley, Chair of the SRA Board, for that welcome. I'm Lex Jones. I'm the Director of AML here at the SRA. We have a busy week ahead with our virtual conference, and we're starting off with anti-money laundering, hopefully going to cover as many questions as we can from our live audience today. Now, I'm delighted to say that our panelists from conference have come back. They're joining me today to share their expertise and experience with you. We did have a really engaging session on the subject at our face-to-face event in Birmingham earlier this month. And the way this session will work today is that shortly we'll move to a recorded segment from the physical conference, which will be about 25 minutes long. Then at that point, we'll come back to our virtual panel, where we hope to answer any questions you wish to put to us. Now, to submit a question, you should be able to see a link. You simply type your questions there, and you can add your name, or you can remain anonymous should you wish to. But for heaven's sake, don't be shy. By all means, do start submitting questions as they come to you during the recorded section, and I'll start putting them to the panel just as soon as the Q&A opens. I would just quickly take this moment to remind everyone we can't answer specific circumstantial questions, so do please make sure you keep them general. But for now, let's get started, and I think I'm first up on the video, so I'm effectively handing over to myself.
As well as welcoming our delegates here in the hall, this session is also being recorded for those who are attending our virtual conference, so welcome also to everyone joining us online. My name is Lex Jones, and I'm the new Director of AML at the SRA. Today I'm chairing this session, which will include a short presentation from our team, before finding out more about our two external panel members and then opening up to questions from our audience. We are keen for this session to be as interactive as possible, so please do get involved. But before we start, we'll do some introductions. We have two external speakers joining us on the panel. We have Natalie Maloney. She's Head of Onboarding and MLRO at national law firm Clark Wilmot. Natalie brings her perspective as a fee earner in a small firm, moving to a national firm. And we also have Alex Newman, Compliance and Operations Manager for Levi Solicitors. Alex has recently been through an AML inspection and is here to share her insight on how she felt before, during, and after the event. But first, I'm going to introduce my colleague, Mandeep Sandhu. Mandeep is Head of AML Proactive Supervision here at the SRA and will take us through some of the key highlights from our newly published annual report. Mandeep.
Hello, everyone, and thank you for attending our AML session today. So I've got 10 to 15 minutes today to cover an overview of our AML supervision in the last year, what firms are getting right, and some of the issues that we're still seeing. And then I'll finish off with some of the trends in the suspicious activity reports that we've submitted to the NCA. So starting off with then is just an overview of the last year. I'm sure you're all familiar by now that we've got three functions within the AML Directorate. So we've got the proactive supervision function, which is the team of guys that go out to do AML inspections and also desk-based reviews, and they also focus on our thematic products. We've got a policy team who issue guidance and help firms understand the regulations, as well as deal with other AML supervisors and law enforcement. And then we've got our investigation function, and that's the team that deal with all of our enforcement cases, which could lead to fines where there's been serious or widespread breaches of AML. So just moving on to some of the work that we've carried out in the last year. As you probably would have seen from the Reg 46 report, all of the data that's in today's slides is from our annual report, so please do have a look at the further detail in that after today. But we've doubled our AML proactive work, so that's double the amount of inspections and desk-based reviews, and we carried out 545 in the last year, compared to 273 in the year prior to that, and that's set to increase again this year. So your chances of being seen has increased quite significantly in the last year and will continue to do so. We also had 227 reports of AML breaches to us, and those reports come in from either law enforcement, self-reports from law firms, but the largest number of referrals into that team come in from the proactive supervision team. And as you might have seen, there were 46 fines relating to AML breaches in the last year, amounting to just over £1 million. And we started off our round of proactive sanctions work this year as well, which I'll talk to in a little bit of detail in the next slide. And finally, our thematic review piece this year focused on AML training, which Lex will cover off in the financial plenary later today. And just one of the things I wanted to let you know as well is we started a new stream of work in the last reporting year, and that was having a look at the results of independent audits for some of the larger firms that we supervise, and that's going to be a cyclical program that occurs every 3 years. So moving on then is just looking into some of our financial sanctions work. I'm not going to go into too much detail on this slide, and the reason for that is we are going to have a webinar in the new year on this area, so please do look out for that. But in the last year, we've issued just over 1,000 letters of guidance to law firms who we considered had weaker controls for financial sanctions and were at greater exposure of falling foul of the sanctions regime. We also carried out 55 sanctions inspections, and that was with those law firms who are actively acting for designated persons. And largely we found that firms were doing really well, but there were 9 firms that were referred for investigation, and that was for breaches of not following the licensing terms or also receiving money from a designated person without a license. And unfortunately, 4 of those firms had only identified the issues when they were preparing the matter for us. But before I move on to AML, I did want to draw your attention to the sanctions risk assessment we issued this year. So please do have a look at that and implement a risk assessment in your firm if you haven't already done so on sanctions, because it is a really good control and it sets out your risk appetite to financial sanctions. Moving on then to AML. As you can see from this slide, it sets out the levels of compliance we're seeing across the board. And overall, we found that most firms are doing really well in this area, and we've helped or worked with at least 394 firms in the last year to better their controls or provide guidance on how things can work well. But as you can see from the not compliant column, 118 firms were still referred for investigation, and that's because we found widespread breaches. So while we do try to work with firms to better their controls, where we do find serious issues, we do need to refer those matters to the investigation team for enforcement. And there were 4 common themes that we found in these referrals, and that was a failure to have a firm-wide risk assessment or not an adequate risk assessment, a lack of AML policies in place or compliant policies in place. Source of funds was a key feature in those referrals, and we also had issues with client and matter risk assessments at law firm level. So moving on then, I wanted to speak through some of the improvements we have seen as well. So overall, you'll recall last year we issued a warning notice, guidance and a template on client and matter risk assessments. And we were really pleased to see the improvements this year. So last year, 51% of firms didn't have effective client and matter risk assessments, and that's had a really positive shift in the last year. So 12% of firms have now got ineffective risk assessments compared to 51% in previous years. And when we say ineffective client and matter risk assessment, what we mean is that the risk assessments we were reviewing weren't covering AML breaches, they were more targeted at business risks, or in some cases, the client was reviewed for their risk, but not the matter. And in some cases, risk assessments were either incomplete or not being filled in at all. One of the other positive shifts we've seen is the adequacy of the way firms are carrying out identification and verification checks, which is at 96% compliance, which is a really good picture. And while we've seen improvements in firm-wide risk assessments and AML policies, there is still some way to go. So with firm-wide risk assessments, we're at 60% compliance now, and policies has had quite a significant shift from 35% to 51% compliant. But there is still some work to be done in this area. So just having a look at some of those topics in a bit more greater detail. Firm-wide risk assessments. So why are some firms not getting compliant ratings? I think the key issues here that we're finding is that a lot of firms have template documents in place, but they haven't been tailored to the firm at all. And we would expect to see that the firm-wide risk assessment is covering the risk that is relevant for your firm. So as you will be aware, our team who go out to inspect either on-site or through desk-based review, they've seen a number of templates by now. And we are quite familiar with those templates, so it's really easy for us to spot when those haven't been tailored. So please do make sure that those firm-wide risk assessments are relevant for your firm and considering all the risks that are relevant to your practice. And another thing we identify which can lead to a not compliant rating is where one or more of the mandatory 5 key risk areas that you're required to cover have not been addressed, and that would lead to a not compliant rating as well. Your firm-wide risk assessment is a really important control because it will help your fee earners understand the risks at the firm and also feed into the client and matter risk rating. So please do ensure you get that right because it folds down into your wider controls as well. We have, to support you, updated our template on the website, and we've also updated our guidance in the hope that we do see some improvements, so please do have a look at that. And we also carried out a webinar in the last year just covering off some of these areas, so please do visit our website to review some of that content. And one of the other things I wanted to draw out is that unfortunately 12 firms didn't have a firm-wide risk assessment in place, which is obviously quite a concern given it's been a requirement for 7 years now. So moving on then to AML policies, one of the common issues, again, we're seeing in terms of why firms would get a not compliant rating is that the policies are either out of date to current legislation or they're not covering the mandatory requirements. Now, this table here is a small snippet of the wider table in our annual report. So one of the tips I would give you is to please have a look at our annual report and see the common missing areas in your policies and see if your policy does address that. And do also have a look at Regulation 19, which lists all of the mandatory areas that you're required to cover in your policy just to cross-check that your policy is compliant with the regulations. But just looking at that table briefly, as you can see, the top 2 areas are the 5th money laundering directive. Now, that's been in place for 4 years now, and we would expect when we're reviewing a policy at law firms for that to be implemented now. And just using the inspection table as an example, 60% of the policies we reviewed didn't cover off the assessment and mitigation of risks associated with new business products or technologies. And what we mean by that is things like cryptocurrency, what's your firm's appetite to that? Have you folded out new e-verification systems? Has that been set out? Has there been no changes? Because it's a mandatory requirement for you to cover it, you do still need to address that even if there hasn't been any changes. And one of the other common areas that are missing in policies is the requirement to report discrepancies to Companies House, which at desk-based review level was missing in 48% of policies. And that's had another legislative change since the 5th Money Laundering Directive, with it changing to material discrepancy, so we expect to see that covered by now. There is guidance on the 5th Money Laundering Directive on our website, so please do have a look at that. And then two of the other top areas that have been coming up as missing in policies for the last few years now in our annual reports is reliance and simplified due diligence. And what we know is a lot of law firms don't permit either of these two, but your position should be set out in your policies so your fee earners are aware about your approach to those. Moving on then to source of funds, which I touched on briefly as being one of the reasons for some of the referrals we're making to the investigation team. This has been another area of concern for us in the last year, and it will be the focus of our next thematic piece for the next reporting year. And the reason for that is that 25% of the files we reviewed at both inspection and desk-based review level didn't contain information or evidence of source of funds on files. And while several of the firms were able to provide us with an explanation of the inquiries they made, there was no real audit trail to substantiate those inquiries. And unfortunately, in several of the files that we reviewed, the transactions involved matters that are highlighted as high risk in our sectoral risk assessment, so conveyancing, property purchases being key, and cash transactions. So we would expect to see some level of source of funds on those matters. That leads me nicely onto why it's important to make sure you have these robust controls in place and why we're focusing on source of funds as our thematic piece for the next year. So in terms of the trends in suspicious activity reports we're seeing, we submitted 23 to the NCA over the last year, and that totaled to about 75 million worth of pounds. And what we identified is conveyancing is still the highest risk for the legal sector in terms of money laundering. And 73% of the SARs we submitted did involve conveyancing transactions, with a large proportion of them relating to residential conveyancing and a small number focusing on commercial properties. And in most of the SARs that we submitted, a lack of sufficient due diligence and source of funds was a key contributor which led us to submitting those SARs. And one of the other things we identified was that in some instances, law firms had actually obtained the information, but they hadn't properly scrutinised it. So I think what might have happened is they've obtained a bank statement, but they've not really looked at any of the red flags that were existing on that transaction, which led us to then submit a SAR. Some of the other trends we're seeing in suspicious activity reporting is vendor fraud is still an issue. We've also seen the client account used where there's been no real underlying legal transaction, so contributing towards that placement and layering. And we've also seen funds from high-risk jurisdictions featured, as well as the involvement of third parties, which again are risks highlighted in our sectoral risk assessment. And two of the other themes that we've seen this year is we've submitted our first SAR on proliferation financing this year, and we also submitted 2 reports to OFSI for sanctions breaches totaling to about 369,000. So that brings me to an end of my content, but I just wanted to draw your attention to the guidance that we do have on the website. Please do have a look at our annual report. We've recently published our thematic training piece on there, and we've also issued guidance on various other areas and carried out 3 webinars over the last year. So please do use those resources to support you. I'll hand you back over to Lex now.
Thank you, Mandeep.
Now, look, there's no pause for applause on my timing schedule. Don't throw me out. Look, we'll come out to the floor shortly for questions, so do please hold on to those if there's anything you want to ask. First, though, I want to bring in our 2 external guests, Natalie and Alex, and find out a bit more about them both. Alex, can I start with you? Can you tell us a bit more about where you work and what your day-to-day role involves?
Yeah. So for Levi Solicitors, which is a relatively small law firm based in Leeds, we deal primarily with conveyancing, wills and probate and litigation. Considering the size of the firm, we do quite a lot of conveyancing for the number of for the size of us. So yeah, on my day-to-day basis, my role is everything to do with compliance. So I deal with all the source of funds queries, ID queries, all the renewal of practicing certificates, insurance, everything, compliance.
Okay, wow, all right. So you've recently had an SRA inspection. Can you tell us how you found it, what the experience was like?
Yeah. So I've always told everybody that within the firm that it wasn't a case of if we had an inspection, but when. But when the letter came through to advise that we were being inspected, my initial reaction was just one of fear, I think. Felt quite sick. That was my initial reaction. Then I kind of dusted myself down and thought, right, okay, let's deal with this practically now. Make sure that everything's in order. Obviously tell everybody within the firm and what to expect. I read everything that I could possibly read about other people that have had inspections, spoke to as many people as possibly could that had had the inspections themselves, and just tried to get ourselves as prepared as we possibly could.
Okay. Yeah, I absolutely recognise that idea that, you know, having someone to check what you do on a day-to-day basis is absolutely terrifying, even though you do it on a day-to-day basis and you absolutely know your staff. I will say the SRA have an oversight regulator, and we definitely have the same sort of deep breath, we can get through this kind of approach. But Alex, we got a room full of people here. Again, lights are low, so I think there's a room full of people here. What would be your advice to others who are expecting an inspection?
I think to make sure that you're 100% comfortable with your own policies and procedures. We will all have our policies and procedures in place, hopefully, but to read through them and make sure that you understand them to the extent that if you're asked any questions about them, you can explain it. I did that, and I realised that there were parts of our policies that, whilst they were compliant, they weren't as clear as they could have been. So we kind of went through those and made sure that I was comfortable and confident with those, and that everybody else in the firm was as well, that they could answer any questions that they needed to. So I think that's the main thing, is just to obviously get yourself up to speed with your own policies and make sure that they're relevant to your firm and they fit.
That seems like really sensible advice, and I would always echo that point around, you know, clear English, clear language that people can understand. After all, if you can't understand the policies that you're attempting to enforce, how is anyone else within your firm going to understand what, you know, the work that they're meant to be doing? Thank you. We'll move on now to Natalie, who has taken part in this event before, so frequent flyer. But you obviously had a different view last year, Natalie, because you've changed roles since we last spoke. Can you tell us a bit more about what it's felt like for you going from a small firm to a much bigger firm?
Yes, so I was on this stage in 21, so it was very much, you know, coming out of COVID, and we'd just had an SRA audit. And I think in a small firm, it's very lonely, much more lonely than I feel now. And also the juggle of trying to be a full-time fee earner, you know, the constant time recording, demands from clients, billing every month, and juggling all the regulatory work that I was doing. That was very difficult, but I really did enjoy the regulatory work when I could get the time to do it. Obviously, my top point was not being scared to death standing on the stage, but anyway, here we are again. But now I've moved to a larger firm. I have a whole team that help me, which is really good. When I was in the smaller firm, it was really good when I did bring in a deputy to help, and I think that's always good advice. And I think, you know, across all the firms I've worked in, everyone wants to do the right thing, and it's just, I feel now I have a lot more time to devote to it and to help. But also, when you're in a larger firm, you don't have as much day-to-day connection with all the fee earners, and that's where I concentrate a lot of my time trying to build those relationships, because we're an onboarding team, so we're separate, and we try and speak to them regularly, whereas when you're a fee earner, you're in a lot more day-to-day contact. But yeah, so very different experiences.
Wow, that must have been quite a change.
How would you describe the culture of compliance? Is it significantly different?
No, I think, as I said, people want to do the right thing. I think I'm very much a believer in the right culture in a firm as well, which I think helps. Very much open door. People can, ask me anything. Nothing is a silly question. And I think small firms, like I said, a lot of the people who are working in a compliance role will be struggling to juggle numerous roles, and I think it's very difficult. And definitely having deputies and making sure that the compliance work is just as valued. I think that's the problem when you're a fee earner, that you need that time. You can't do everything. It's very difficult.
And how do you tackle those conversations then with fee earners going, I need to earn some money. I don't want to be doing forms or onboarding.
I know. So I think what I say is, if we get it right at the start, it makes life a lot easier. Obviously, we have in Clark Wilmot, we have a lot of clients who've been with us for a long time, and this is, sometimes quite a shift, the amount of information we're now requiring, source of funds particularly. But if we can explain that's what we're going to need, because that's the environment that we're now in, I think that's a lot easier than keep going backwards and forwards asking for things. That can cause a lot of irritation. And I do appreciate fee earners, want to get on with the job. So I think we did a lot of work last year with the support staff and the secretaries to make sure that we're putting in the right data right at the start, so we're not going back and asking you in a week's time what's your date of birth, because that's irritating. Yeah. We should have asked you on the first call. And I think that is making things a lot smoother for our clients. And I understand the pressures we're under, I understand deadlines, so we need to get files open as quick as we can. And that data is key, I think, to that.
Okay. So picking up on a point I think you were making there then, how important is it for you to get things right at the onboarding stage?
So that's the key message, I think. We have electronic verification. If we haven't got all the right information, it's not going to pass. We need to educate our clients so that they're not nervous. Everyone's very nervous when they get links, especially, older clients might not have a smartphone. My mum wouldn't be able to do a selfie. She wouldn't know where to start. So I think, it's this education piece and being able to help people that will struggle with these things. And I think if everyone understands what the process is, I've done lots of these checks myself, but I invite anyone in the firm, if they want to do one of these checks, they're very welcome to do one, because they can see it takes under a minute. And I think it's that education piece. So on the day that you phone me and you want me to take on your case, we can actually send you the link, and you can complete that within an hour of it going through our process. So that's how quick it can be if we get the right information. So getting it right on day one means we can open your file. It's not going to freeze. You're not going to be in trouble, and not be able to push forward with the case, which is what everyone wants to do.
Of course. Yeah. All right. Thank you. So I think, and to the wider panel now, we're interested in appetite to risk and the common queries you receive in your role. Alex, what are some of the most common queries you receive?
Mine tend to be around source of funds, and in particular, the fee earners will say, well, how far back do I need to go with my source of funds? And I'll always tell them to look at the specific details of that case. And whenever I answer a question, I always say, I'm very conscious that I may have answered very similar circumstances in a different way. I may have given a different answer last time, but it's because there's a slight difference in each case. I think that is the main one, or the fee earner will gather all the information and then come to me and say, is this all right? Yeah. And I always bounce it back to them to say, well, is there any reason for suspicion first off? I can look at the data you've given me and see whether it looks okay on the face of it, but I've never spoken to the client. I don't know if there's any other reason for suspicion, so I think that tends to be the main one.
Okay. And Natalie, what about you? What are the most common queries you receive?
I mean, we get a lot on identification and verification. We were laughing earlier, weren't we, that some of the photographs we get are really quite shocking.
You guys should have been backstage. It was amazing.
And, a lot of the time we are dealing with queries on source of funds, because no case is the same. We need to understand, we need to be looking, and it really helps that I think the more we talk to the fee earners, the more they understand what they're looking for. It's not just send us the kitchen sink and we'll work it out for you. And I think that I gave a gold star to some of my teams when I went round this year, because they're getting so much better at getting the right information to start with, and then we'll obviously look at it once it comes in. But yeah, source of funds and identification and verification are the big ones, really.
And so what helps you the most in your jobs there? Are there checklists you use, or sort of, I don't know, mnemonics to help people navigate different scenarios?
I mean, I think one of the forms that I'm always referring to, it's not a checklist as such, but it's our source of funds information sheet, and it's got all the different types of funding that could come in. So it could be, you're cashing in your pension, could be a form of sale of a property with another firm. And it just gives lots of information about what we're going to ask for if it's one of these situations. And I think that is a key, because we send that out, and the fee earners can send that out to their clients. It builds the picture of if you're funding it in this way, we're going to want all of this. And quite often, very often now, we're getting bank of mum and dad in the conveyancing, and I'm sure Alex has got this. And then it's no good mum and dad just giving you the money. We need to understand where mum and dad have got the money from. And it gets quite intrusive. I think people think if it just comes to the child, it's going to be okay, but it's not. And I think explaining that in the initial meeting so that they can see, we want to understand where your mum and dad got the money from as well, and not just because we're being nosy, it's what we need to understand. Yeah. And I don't know if Alex would agree.
Yeah, I do agree with that. I think with the fee earners as well, sometimes if you do get parents that are reluctant to give that information, the fee earner will just say, well, this must be suspicious because they don't want to give the bank statement. But when you actually delve a little bit further into it, it's just that they don't understand what you're asking for or why you're asking for it. So I think educating the clients and the fee earners as well as to how to ask for the information. If most clients you ask for the information, they give it. If there's any reluctance, then we've tried to train the fee earners to say, actually, could you ask a couple of more questions? Could you pick the phone up rather than send an email so that you can gain that trust and get the information? And if they're still shut ranks, then it might be suspicious. But
okay. I like that, though. Context is key, and really kind of explain to people why you want that information. It's not just because you're desperate to know where they do their shopping every week, is it? You are looking for a specific reason. Mandy, when you and your teams kind of go out across different firms, are there different things you see that you think, this really helps them, work through things? Are you seeing, good examples of checklists used or, other methods?
Yeah, we've seen varying degrees of methods. Some of the checklists do look really good. A lot of firms are now folding in the source of funds checks into the client and matter risk assessment, which keeps it all in a central place. We've seen really good practice of ongoing monitoring as well. So if funding's changing throughout the transaction, that being picked up throughout. But I think the best practice we see is when people understand where the money is actually coming from, rather than we've got a bank statement, we can see that the 60,000 is sitting there, but there's no real understanding of how that was accumulated. But detailed notes is the key. One of the things we do find, which every time we go out, either for an inspection or a desk-based review, is we ask firms to provide us with a summary of the transaction. And often what we're finding is that summary that they've drafted for us has a lot of detail that's missing on the file. And I think if that was just reflected at file level, if you know it, that would be half of the compliance functions being met. Because often fee earners are aware of where the information is coming from, but it's just not documented.
Well, welcome back to everyone. And I'm now joined by the panel to take your questions. Some of them have been coming in thick and fast, so thank you to everyone who's already put their questions in. But a quick reminder, you can still use the link in the description to ask more questions as we go through. Before I move to some of the questions that have come in, though, I will ask the panel one of our opening questions that we didn't get time to cover in the live event in Birmingham earlier this month. So, to the whole panel, does the panel think that the requirements for source of wealth checks are confusing for law firms, and what suggestions do they have? And Mandeep, I'm going to come to you first, if I can, please.
Thanks, Lex. In terms of our findings, in terms of what we see on site, we see that there is good source of funds checks and wealth checks when they are carried out, and that distinction is there. But just in terms of just setting that out for the audience, source of wealth checks is understanding the entire wealth of your client rather than the way the transaction is specifically being funded. So what you'd want to understand is how did the individual who's instructing your firm come to amass or amount the overall assets that they hold. But in terms of if those requirements are confusing for fee earners at your firm, some of the really good things to point them to is the outside guidance, which sets out the requirements of source of funds and source of wealth checks. But also, if you're seeing it as a common issue, training is a really good control. And setting out some training in that area on the differences between source of funds and source of wealth is another good tool to assist you. I don't know, Alex and Natalie, if you want to come in in terms of how that works at your firm.
Yeah, I think the training is a good way of dealing with it, particularly using real life situations. So anonymizing the details of the client, obviously, but putting that information out to the client, to the firm and to the fee earners, so they can see what kind of things you are actually dealing with on a day-to-day basis, real life situations.
Yeah, I would agree with Alex. And we, with our new starters in our induction program, we use a red flag, green flag sort of game where we use real life examples that obviously we've changed the names. And that really shows where the understanding of wealth helps us make decisions and does it make sense, what our client is telling us and what we know.
All right, thank you. Well, look, we'll go to the virtual floor. I guess this is really, isn't it? But one of the questions coming in, no name on this one, but what is the best approach to take when dealing with elderly clients who have an expired UK passport and driving license, but we can still meet them in person? Alex, could I come to you for your thoughts on that one?
Yep, sure. This happens quite a lot, obviously, with the elderly clients that are able to come into our offices with whatever ID they've got. What I always say to the fee earner is to just gather as much information as you can from the client. So if they've got an expired passport, they've got a pensions book, something from the DWP, that kind of thing, meet the client in person, make sure that they're fully aware of what you're doing for them, the transaction. And to then you can't run the electronic money laundering an ID check as you would in the same way if they had an in-date passport, but run your standard AML process and just see if that brings any flags up sometimes, because it'll run the deceased check and that kind of thing. And if you need to gather more information from the client, more evidence of identity, then you can do. But yeah, I think just to get as much as you possibly can from the client.
Thank you. Mandy, did you have any thoughts on that one from the SRA's perspective?
Yeah, I would just come in and say what other additional documents can you obtain, and what's the circumstances of the client as to why they don't have a passport. So, for example, asylum seekers might not have a passport. Can you rely on GP letters, other types of bills that they might have? So, really probe and understand. And I think documenting that in your client and matter risk assessment is a really useful tool as well in terms of why you collected the verification and identification documents that you did and why they made sense for that type of a client.
Super, thank you. Okay, so next question. Provided it is transparent and explained to the client, is the charging of a standalone onboarding fixed fee permissible for new matters? Mandy, I'm going to hand that one to you, please.
Yes, it is. So we've covered this off in our Q&A on our website, so please do have a look at those. It's absolutely fine for you to charge for due diligence checks and pass on those onboarding checks to your clients, but you do need to be absolutely transparent about those checks in your terms and conditions and set that out to your clients at the outset so they do know and are made aware about those charges.
Super, thank you. And a question in from Sonia. Thank you, Sonia. What is the best place to stay up to date on changes in AML and compliance, and what is required? Natalie, maybe I could bring you in here.
My personal favorite, I like LinkedIn because people like Mandeep will post on there when new guidance comes from the SRA. And you can follow the SRA, you can follow individuals on there. So I find LinkedIn really useful. And also, obviously, the SRA have their website with updates on it, and the Law Society do too. So I think that's where and obviously there's lots of webinars that I attend, lots of lunchtime webinars run by various different providers. So I use those a lot.
Perfect, thank you. And Alex, from your perspective, is there anything else that you would use?
I think LinkedIn is the main one. There's so much information. I think when I first started, it's really easy to get bogged down with information overload, because you kind of sign up to various newsletters and news bulletins, and whenever there's any kind of update, you just get bombarded, and it's trying to work your way through the information and find out what you actually need to know is quite difficult. Whereas I think on LinkedIn, if there's a couple of people posting about the same thing, you kind of know to either go and look for further information either on the SRA website or one of any other source that you use. But yeah, I think I'd agree that LinkedIn's the best place.
Okay, thank you. I totally get where you're coming from when you talk about that kind of information overload. There's always that sense you can't see the wood for the trees sometimes, isn't it, in terms of the amount of information that's out there. Next question is come in from Philip. Thank you, Philip. If a client is unable to provide an acceptable explanation as to source of funds and we have no evidence of criminal activity, are we expected to submit a SAR to the NCA, but no defence sought due to having no evidence of actual criminal activity? Mandeep, you want to take that one?
Sure. So I think your starting base is to really understand why the client doesn't understand where their source of funds have come from and why they can't provide that explanation, and whether you consider that to be a risk which would require an information SAR. And if you're happy as a firm, based on your risk appetite and your firm-wide risk assessment, to continue with that transaction. The other thing I'd like to highlight in terms of there might be a bit of a misunderstanding there in terms of the reason for a defence is when you've already you're partway through and you want consent to proceed. So just setting out those two requirements there in terms of the difference between an information SAR, that's feeding intelligence in to the NCA, and DAM or defence is consent to proceed. So I think just in terms of it's quite a vague question, but you really need to understand why the client initially can't provide that explanation to then understand whether there is any proceeds of crime there or criminal activity.
Okay, thank you. And then, so actually staying on source of funds, source of wealth, how detailed should source of funds checks be for routine transactions compared to those that might involve politically exposed persons or high-risk jurisdictions? And Mandy, I'll come to you again, but then I might move out to Natalie and Alex as well.
Great, thanks, Lex. So for politically exposed persons and high-risk matters and jurisdictions, the requirement in the regulations is actually to carry out source of wealth checks as well. So it's not just source of funds checks. But the key thing here isn't a list of the source of funds checks or the detail that should be carried out. It's really about understanding the risk of the matter. And if you understand the risk of the client and the matter, that would inform the level of due diligence you're carrying out and the source of funds checks you're carrying out. So what do you understand about the client and the matter? Why do you consider them to be high risk? What level of checks do you then need to carry out? Does it make sense for the client to be instructing you on this matter? Is the transaction, in line with their profile and what you know of them? And then that should really help you understand the types of checks you should be carrying out and the level of detail you need to go to. The key thing to note here is the purpose of the source of funds and source of wealth checks is there to enable you to understand that the money that you're accepting or the transaction that you're instructed on doesn't involve the proceeds of crime, and it is one of the best checks for law firms to carry out. So I think your starting base should really be, where is this funding coming from? Am I comfortable with the funding and where it's arriving from, and that it's not the proceeds of crime? And then what level of checks do I need to do to understand for that PEP, for the high-risk jurisdiction, to make sure that I'm satisfied that this transaction makes sense? So it's really about understanding the risk. And then obviously, please do make sure that when it is PEPs and high-risk transactions or high-risk jurisdictions, that there is also that additional requirement to carry out source of wealth checks dependent on the risk of the matter.
Okay, thank you. And Alex, if I come to you, does that chime with you? Is there anything else your firm would do or consider?
I think just taking each circumstance as it is. There's no kind of checklist. There's no standard that we have to say these checks must be carried out in these circumstances. It all does depend on the individual circumstances. So really think about what your client's trying to achieve, your client's background, and the whole kind of picture, and not just focus on the source of funds or the source of wealth. Just what you know about your client as a whole.
Yeah, absolutely. And Natalie, what about you?
I mean, I'd very much agree with Alex. I'm always asking when someone comes to me, what's happening here? What, is it mortgage monies? Where is the money coming from? We always really need to understand, what is behind this. And like Alex says, no transaction is the same as another. Even if it's for the same client, we just need to keep understanding.
Okay, thank you. Moving aside slightly from source of funds checks for the moment, another question's come in. No name on this one. There is very little guidance on counterparty measures. Are you able to shed some light on what is expected when it comes to completing our AML requirements on counterparties? Mandy, did you want to take this one?
Sure. So if you again visit our AML Q&As, we've addressed counterparty due diligence both for AML and sanctions. In terms of for anti-money laundering, it really depends on your need and again on risk. So you might need to carry it out, and there could be a requirement in the regulations as well. So any transaction that's based or established in a high-risk third country, you're required to carry out counterparty checks. But it really does depend on the level of checks that are appropriate for the risks identified in the specific matter. And again, with sanctions, it's one of the things that we highlighted as an important control in terms of understanding the counterparty, because with sanctions, you need to really understand the ownership and control element of a counterparty and of party. So understanding that counterparty is quite a good control in terms of carrying out those due diligence checks to make sure there's no sanctions breach.
Okay. All right. And Natalie, I'll come to you first. Is that something that sort of marries with your firm's approach, or you know, are there other considerations that you bring to bear?
I mean, we've now moved, and like as a firm, we now check our counterparties, and we're training on why we're doing that. So that's been a shift that we've done during 24, and we're just gathering that information at the start. And if anything changes, we want the fee earners to tell us so that we can check again. So yeah, we are checking our counterparties now.
Okay, thank you. And Alex, what about you?
Yeah, the same. Yeah, nothing more to add.
Okay, thank you. So next question then. Oh, Mandy, I think this one is just going to be straight for you. Is the new SRA client and matter risk assessment form mandatory or just strongly recommended?
Yeah, so the requirement to carry out a client and matter risk assessment is mandatory in accordance with Regulation 28, 12 and 13. You don't have to use the SRA's template, it's there as a guidance piece for you to use. Even when firms do use it, we encourage that they tailor the template to fit their firm and the firm's risk profile and firm-wide risk assessment. So in terms of using the SRA template, no, it's not mandatory for you to use that, but in terms of risk assessing at client and matter level, yes, that is mandatory in accordance with Regulation 28, 12 and 13.
All right, thank you. And oh, Mandy, I'm sorry, it's another one for you, but wow, are you getting your moment in the spotlight here? What is reliance?
So reliance is covered off in Regulation 39 of the money laundering regulations. So do have a read of the detailed requirements in the regulations directly themselves. But in a brief nutshell, what reliance is relying on another party, so for example, estate agents, to carry out the due diligence checks. But the really important thing to notice with reliance is you would still remain responsible if things went wrong. And there's a couple of things you need to have in place to enter into a reliance agreement. So you need an agreement in place with those who you're relying on for those due diligence checks, and you also need to make sure that those documents are accessible as and when you need to request them in. But I think the key thing to point out with reliance is that the responsibility ultimately will still rest with your firm if you do choose to rely on the due diligence carried out by a different party.
Okay, thank you. So this next question will be for Mandy, but actually I think I'd be interested in the views from Natalie and Alex as well on this. So the question is, you mentioned that 25% of the files reviewed had no evidence of source of funds. Of those files with higher risk factors like PEP, etc., would you expect to see source of funds on every single matter?
So in accordance with the regulations, you are required to do on a risk basis source of wealth checks on PEPs and high-risk third countries, just because they obviously are high-risk matters. The level of due diligence you then carry out is determined on the risks that you set out in your client and matter risk assessment. So the requirement isn't just about source of funds checks on the matter, it's actually source of funds and source of wealth, and you should really be able to explain, if you're not carrying those out, why it makes sense for that transaction, and document the level of checks you're carrying out and why you've taken that approach.
Thank you. And Mandeep, just quickly as well, are you able to articulate the difference between source of wealth and source of funds for everyone on the video?
Sure. So source of funds is understanding the level of assets that your firm are due to receive for that specific transaction. So using a purchase, for example, £250,000, you want to really understand how the client came to have that money for that specific transaction. There is a degree of needing to understand the client's source of wealth to some extent, in terms of understanding how they've acquired those source of funds. But source of wealth is more of an overarching view of how the client has their assets in total, so how they accumulated their full wealth and whether it made sense. So that's the two different requirements, but they can start to blur into one. For example, if you're checking someone's salary and whether that made sense for the deposit that they're putting in, that arguably understanding their salary could give you a bit more of an understanding of their overall wealth as well.
Thank you. So kind of expanding that question out to Natalie and Alex now. For your respective firms, or just perhaps within your experience, do you expect to see source of funds on every single matter, or do you simply reserve that for the higher risk cases?
It would be every matter, source of funds and kind of source of wealth. I think the way we treat them is as one in a way. To have a real understanding of the source of funds, then you need to have a little bit of an idea about the source of wealth, and obviously depending on the circumstances as to how far you go in terms of source of wealth. But yeah, absolutely, I'd want to see it on every single file.
Thank you. And Natalie?
I mean, if it's the nature of the work that's been undertaken. So obviously on transactional work, we would expect to see that. And it's just really very much based. And like Alex says, our form that we complete for source of funds does include source of wealth as well. And when I train, it's very much training the fee earners. You know, we get to know our clients, and you get to know a lot of this. Like Mandeep said, if you're looking at pay slips, or you might be talking to them, you know, building those relationships is where you're going to get a lot of the information. You know, we might act for a company director, but we've acted for his company for a number of years. So through that previous work, we'd have that understanding of the wealth, because he's, you know, been successful in that company. So it's pulling all of those strands together.
Lovely, thank you. Alex, this one's for you, because it's an issue I remember you addressing in the live conference. It's quite a long question though. So when your firm has been notified of an inspection, and as part of your role, you're responsible for reviewing policies and procedures, you see that your firm is compliant, but you think you could have clearer policies and procedures. Do you simply kind of note these improvements, ready for any questions during the inspection, or do you get to move on and basically start changing them before the inspection takes place?
Okay. So for ours, I did make the changes, and I think that's probably what I would encourage anybody to do, but make sure that it's documented, the changes that you've made. If you find that something needs to be clearer, then it needs to be clearer whether you're being inspected or not. So your staff need to have an understanding of it. Prior to our inspection, I read through policies and thought there's little bits in there that I don't quite understand myself, or I can't explain properly enough. So I made those clearer, but I have an ongoing checklist, well, not checklist, but an ongoing record of any changes that I've made, any updates that are sent out to staff, so it's clear that if the SRA asked to see a previous policy and the new policy, that it's not just a complete change. There's a reasoning behind it, and there's a record of the changes that have been made, just so that you understand them yourself and you can see when a change was made. So if you're reviewing files and somebody's not following the new procedure, you can say, well, actually, as of whatever date it changed to this. You've just got a backup for yourself then.
Lovely, thank you. We've got the last few minutes of questions now. So if you've not already submitted and you've got something you're desperate to ask, please do type quickly. Get those questions submitted. Next one in there, I think, Mandeep, probably for you again. It's on firm-wide risk assessments. is it necessary to document that you have read all publications, guidelines, etc., even if it's not applicable to their specific firm? So, for example, overseas AML.
So Regulation 18 requires you to consider the information your supervisory body has published, which would be us, and also to consider our sectoral risk assessment. In terms of all of the guidance documents that you've read, what I would encourage as good practice is to document it, because it could be, what's the reason why you're considering those documents? Is it for training purposes? Is it to develop your own AML expertise? Is it because you're sharing that with the firm? So keeping a record of the documents, whether they contribute towards training at your firm or your own understanding of ongoing and moving money laundering risks, is good practice generally, but specifically for the firm-wide risk assessment, you need to consider the information we've published as the SRA and also our sectoral risk assessment. But then also, if you have considered guidance on overseas, documenting it, why it's not relevant for your firm to inform your fee earners, that's again a really useful tool.
Okay, thank you. And a quick question here, I think, but Mandy, again, back to you. Can you combine a client and matter risk assessment into one document?
You can. So ours is combined, or we've seen it be combined, and we've seen both separated as well. So as long as it's covering the mandatory requirements in Regulation 28, 12 and 13, the method you choose in terms of how you risk assess at your firm is really down to you.
Okay, thank you. And then we have a question in from Joanna. Various members of the panel have mentioned that they verify their counterparts now. They said, what providers do they use, I think, and how are they obtaining the information? I should probably just weigh in here and say we can't obviously endorse any any provider out there. I think the one thing that I would say, though, is when you're buying any kind of package or resource, etc., you're kind of outsourcing that work, you really want to make sure you've understood exactly what it is they are and are not doing, what they are and are not capable of providing, because ultimately the responsibility for making sure those checks are done properly comes down to you. So even if you've outsourced it, ultimately the responsibility for making sure those checks are complete and done properly is still yours. So really dig into and do your due diligence on who the best providers are out there, and then make sure you keep that knowledge current as well. So make sure you keep refreshing your understanding of who's the best provider out there, to make sure that you're meeting the risk appetite for your firm. And then I think we've got another couple in. Just fine. Oh, here we go. So it's source of funds and source of wealth. Again, a very popular topic, clearly. Do you need to do source of funds and source of wealth if the money coming in is for fees and disbursements only, not transactional work? So for areas of advice on contracts, litigations, etc. Mandy, are you happy to take that one?
So the litigation actually isn't in scope of the money laundering regulations, but what I would say with litigation is just be alert to sanctions risk, and if you need to ensure that that's not a designated person that you're acting for, and if you were in that case, source of funds checks could be quite helpful in determining whether you are receiving fees from a designated person, because that wouldn't be permissible without a license. But in terms of just in the where you mentioned that you're not dealing with transactional work, not having a client account or not dealing with transactional work in itself doesn't mean there's no money laundering risk. So in accordance with POCA, and I'd really strongly encourage you to read our POCA guidance, which is on our website. Arrangement offences can still occur without the transfer of money through your client account, or where you're just taking in fees and disbursements. So you really do need to understand, as part of your risk assessment, whether the transaction you're assisting in could lead to an arrangement offence or the movement of assets, even if they're not necessarily being transferred through your firm.
Thank you. Look, I think we've probably come to the end of our time slot now, unfortunately, or fortunately, I guess, but for our panelists, you might be going, "Oof, there's a lot of questions here." So a big thank you to Alex Newman and Natalie Maloney for joining us for the virtual conference, and thank you, Mandeep, as well, for providing such amazing support and answering so many questions. We have covered quite a lot in this session, but if you do want more information or to look at any of the SRA guidance we mentioned, then links to resources will be in the description, and that'll include a link to our latest client matter risk assessment bite-sized session, just in case you missed that at the conference. Now, inevitably, I'm going to ask you for feedback as well. We would really like to hear your feedback. Let us know what you thought of this session by clicking on the feedback link. It will only take a minute, and it really will help us improve what we do. There are other webinars taking place all week, so if you've enjoyed this session and you enjoyed the compliance conference, then please do sign up to the other webinars as well. But otherwise, thank you very much for listening.